Mr. Lockhart,
Yes, hello?
are you, you've been here before, correct?
Yeah, I've been here before.
Have you made any kind of filings on your behalf?
Yeah, quite a few.
This is the city of Detroit versus Jamil Amir Lockhart. Appearance for the record, please.
Yeah, so I am Jamil of the family Lockhart. The motions that I filed and the documents that I've filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action? Criminal. Okay. Your Honor, the Constitution grants this court two criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 17 of the Constitution.
There's a clear misunderstanding of constitutional law being presented here. Article 1, Section 8, Clause 17, commonly known as the Enclave Clause, has a very specific purpose. It authorizes the federal government to establish and govern the District of Columbia and certain federal properties. That provision does not create exemptions from criminal law, nor does it grant individuals special status outside legal jurisdiction. It is a structural rule about federal authority, not a personal shield against accountability. Treating it as a loophole reflects a fundamental misreading of the Constitution. It is a basic legal framework, not an escape mechanism from lawful consequences.
So in which of these two criminal jurisdictions does the court intend to try me?
Where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings and conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you
to disclose it to you. Check the court rules, sir.
Well, Your Honor, the Sixth Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand which jurisdiction the court intends to proceed to conduct a defense.
You have a very good attorney on the line, Mr. Elwood Terry. If you want to speak to him in a breakout room, I can give you that opportunity. Other than that, I'm going to set a bench trial or a jury trial in the matter.
Okay. Please let the record show that I have attempted to understand or to ask what is the jurisdiction of the court is operating under. And it appears that the court is operating under a secret jurisdiction. Maybe only known to bar members and licensed attorneys. So let the record show that I am trying to understand jurisdiction and nature of cause against me, and the court has denied me that information.
I'm not denying you the information. The information is public information, sir. The information is outlined in the Michigan court rules. You need to read the Michigan court rules, and you can find out jurisdiction. It'll tell you everything about jurisdiction. That's entirely public information. You can go online and type in the court rules, the whole book. That ascertain to you online.
Sir, the Sixth Amendment grants
I'm
you
not required
to inform me of the nature and cause of any action brought against me. And right now, you're denying me that right.
I'm going to tell you, sir, don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving drive while license not valid or improper. The other charges, no insurance, misdemeanor. The allegation is that you were driving the same 2011 Jaguar in the city of Detroit without the proper registration on that vehicle.
Once again, the familiar pattern emerges. No valid license, no insurance, and no proper vehicle registration. All key legal requirements missing. These are not optional formalities. They are baseline conditions for operating a vehicle on public roads. Public roadways come with shared rules designed to protect everyone using them. Ignoring those rules while still benefiting from the infrastructure creates an immediate legal problem. The surprise expressed afterward is misplaced. When the same choices are made repeatedly, the same outcomes are not unexpected. They are inevitable.
I understand the
The
claim.
maximum don't interrupt me, sir.
Okay, go ahead. I'm sorry.
Those are the charges. Do you want a bench trial or a jury trial?
Your Honor, I am trying to understand the jurisdiction of this court.
And I told you,
As I said, you told me it was a criminal jurisdiction.
If you read the Michigan court rules will tell you and give you jurisdiction. So they have a copy of the Michigan court rules online or at the public library. I'm sure it is as easily ascertainable, and we're not going to keep going down this road, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, it's let's move on to the next person.
Sir, please answer that.
You
It can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question.
Your Honor, I do not wish to be held in contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution is exercise of a constitutional right cannot be converted into a crime, sir.
Yes, the Constitution guarantees the right to be informed of the charges being brought against you. That obligation rests squarely on the court, and it is fulfilled when the charges are clearly stated on the record. What the Constitution does not guarantee is personal comprehension or agreement with those charges. Understanding them is the responsibility of the defendant, not the court. When someone refuses to engage meaningfully or listen to explanations, the failure to understand is not a legal violation. It is a self-created obstacle.
Sir, the way you speak to the court is via motion, okay? If you have a motion that I've already denied one of your motions, if you have another motion,
under what basis? Under what grounds have you denied my motions?
It's not my job to explain to you all of the court rules, sir.
Sir, there's only two jurisdictions which this court can operate under.
You're gonna be treated just like any other lawyer that comes in this courtroom. So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are. I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it admiralty law?
There's also confusion surrounding the concept of admiralty law. Admiralty jurisdiction applies to maritime matters and navigable waters, not land-based criminal courts. Without a maritime context, the argument simply does not apply that a courtroom operating under state or federal criminal law does not transform based on terminology or symbolism. Legal jurisdiction is determined by facts, not wordplay. This appearance concludes with no resolution because the same confrontational approach continues. Rather than addressing the issue at hand, the focus remains on argument for its own sake, prolonging the process without progress.
The record for Mr. Jamil Lockhart.
Yes.
All right. This is the last time I'm going to say this. I'm not going to continue to go back and forth with you regarding court rules and all of those positions that you have. If you put it in a motion, we'll set a motion hearing date.
If you are setting a motion hearing date, you are doing so without my understanding of the nature and cause of the action against me.
Listen,
And
I
cannot move forward until I have these questions answered. These are basic questions that you are obligated under the Sixth Amendment.
I'm not obligated to answer any of that stuff. I told you, I gave you the answer to that stuff by looking in the court rules. You're obligated to know the rules.
Sir, what you mentioned is statutory law. And if we are proceeding under some kind of statutory law, I motion that we dismiss for lack of a sworn complaint or anything signed by injured party. And in fact, where is the injured party? Is the officer present, and who is the injured party in this case?
The officer is not required to be present today. It is a pretrial date. I'll hold that dismissal motion in abeyance until the date of trial. If the date of trial, if there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint.
I'm sorry, is the city the injured party here?
Yeah, you're here.
Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint.
Well, that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
Young man, you got to go do your homework, okay? And it appears that you're taking this position and you're adamant about this position, and you're free to do that. Now, whether you're going to win at this position, that's going to be up to what you say in your brief. And how it relates to the law, and we'll make a decision on that stuff, okay? But at this point, you need to educate yourself, because you seem like a very articulate, educated young man. You need to educate yourself on court rules and procedure. Until you get it correct, we can't talk, because we have to be speaking the same language, okay?
I mean, that's the main thing I'm trying to understand here, sir. Is this a common
So
law criminal procedure?
I'm giving you some direction on.
Well, sir, I don't know which rules. If you could tell me where I could find the rules for.
I told you, go to Michigan court rules. They got Michigan court rules.
They have rules for criminal procedure under statutory law.
Yes, very much so.
Could you please direct me to that?
The claim being suggested here would effectively exempt individuals from all criminal responsibility unless a personal agreement existed. That idea has no basis in law and has never been recognized by any court. Participation in public life, using roads, utilities, and legal protections, comes with shared responsibilities. Rights and obligations operate together, not separately. You cannot invoke legal protections while rejecting the laws that sustain them. That approach is not independence. It is selective compliance, which the law does not allow.
I've already directed you to it. Michigan court rules. There's a book that's over 1,000 pages, and it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules, is that statutory law?
I'm not going to keep going back and forth with you, sir. Whatever motions that you have, that's how you speak to the court, through motions. And whatever motions that you have, I will review it. I read all the motions that come across. I check all the law myself. And if you have some law, I would suggest that law that you're saying that we don't.
Your Honor, there is no international contract. I mean, we've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding. And I'm not aware of any contract. In the absence of such contract, I motion that we dismiss this case.
The court's response is not arbitrary. It is procedural. Interruptions, refusal to listen, and attempts to dominate the courtroom disrupt the legal process and force the judge to intervene. The judge explains that continued noncompliance could result in immediate enforcement actions, including arrest. This is not a threat, but a lawful option available under court authority. Unfortunately, the message is missed because attention is focused on confrontation rather than understanding the consequences being clearly outlined.
And for the record, I would just
in order to, you can move to the circuit court, and you can appeal my decision as it relates to that. But we're not going to keep on going back and forth.
I think we should move this case to federal court. As I stated, if the city is the inter-party,
file a motion so I can, on your removal motion, file a motion.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time. And there's been no evidence of any jurisdiction, and I don't understand why, you're insisting on, moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest. And you don't have to show up. I mean, you'll have to deal with that then. But at some point, you're going to have to deal.
Under what grounds, under what basis are you putting a warrant out for my arrest?
This moment represents a turning point many defendants fail to recognize. Challenging jurisdiction in this manner invites the court to establish it decisively and without ambiguity. Judges are not drawn into arguments. They resolve them. When someone insists on testing authority, the court responds by demonstrating it in practice. What follows often becomes an example for others observing the process, a clear illustration of how refusal to cooperate leads to outcomes far worse than the original issue.
I didn't say I was going to put a warrant. I said, if you're telling the court that you're not going to come back to any court dates, then that's up to you. All I can do,
what I'm saying, sir, is I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit. And the prosecutor can't provide that. And it seems like there's a bias going on here because flat on its face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date. And I don't understand. I mean, your oath of office is to uphold the Constitution. And what I'm asking is,
what you're saying in essence is that I don't have any authority.
I'm asking you to prove your authority.
Facing the possibility of jail time is not the same as having already been sentenced. There is still an opportunity to make decisions that reduce long-term consequences. Accepting legal representation is often the most practical step available. A trained attorney understands procedure, timing, and strategy in ways self-representation simply cannot match. Believing oneself to be an expert does not make it so. Ignoring professional assistance in favor of personal theories frequently accelerates the very outcome one is trying to avoid.